been a lengthy and complicated matter, that's for sure. And to give us a legal perspective and perhaps help us understand it better, we're joined by sports lawyer Paul Horvath in Melbourne. Paul, the burden was on ASADA to prove the Essendon players had taken a performance-enhancing substance. Was that burden of proof simply too high today?
I think that's right, Patrick. I think that the burden varies between on the balance of probabilities and up to beyond reasonable doubt. The burden in this case falls somewhere in between that. And when a tribunal such as the AFL Anti-Doping Tribunal wants to find proven serious allegations where 2-year bans are going to be imposed, players' careers and reputations are going to be tarnished and severely damaged, and indeed Essendon Football Club will be further damaged, and we would see, I expect, another season that would be significantly impacted were penalties to be imposed, that the tribunal simply wasn't satisfied that that level of evidence was put before it to find the serious decision adverse to the players.
Looking at the ASADA case, I imagine a massive problem must have been the absence of Stephen Dank. The AFL Anti-Doping Tribunal couldn't do much to compel him to testify in person, but his absence, surely that's got to be a failing for the system, doesn't it, Paul?
I guess the way the AFL system is set up is that it's all under contract, so that anyone with a contract with an AFL club, that includes players, that includes club officials, coaches, etc., they have to, under their contract of employment, front up in front of an AFL tribunal of whatever description. However, there are those that sit outside that, and Stephen Dank, who no longer has a contract with an AFL club, can't be forced to attend before that tribunal. We saw that shortly before the tribunal processes commenced before David Jones and his colleagues, that applications were made in the Victorian Supreme Court to seek to force Nima Alavi, the compounding chemist who prepared the substances that were allegedly taken, and Shane Charter, who allegedly sourced the base minerals from China, that were then handed on to Nima Alavi, and that application was unsuccessful. So that was a real difficulty once those witnesses couldn't be forced to attend for the ASADA case and the AFL. But that's the system under the AFL tribunal, and at the moment that there's nothing they can do about that.
Will ASADA have 21 days to appeal? WADA have a further 21 days after that. Would you anticipate we've seen the end of this?
It's difficult to say, Patrick. I would expect that there'd be an extensive decision setting out the various reasons as to why the tribunal panel of 2 ex-county court judges and a current practising barrister, why they aren't comfortably satisfied by the evidence. I'm aware that there was hundreds and hundreds of pages of submissions put in at the end of the hearing, and that's on top of the many, many days of transcript and evidence given by various people during the hearing. So there could be a whole host of points of evidence that were focused upon in the reasoning by the panel. My sense is that it will be difficult to mount an appeal that is likely to succeed, but that'll very much depend on how the decision is written. Now, as I say, being 2 ex-county court judges and a barrister, you would think that they'll write a fairly sound decision, and they've had over a month since they've been given the final reasons by each party as to why their side should win the case. So I expect it'll be a fairly watertight set of reasons, but in saying that, we know that these matters are obviously taken very seriously, and if there's any skerrick of hope of an appeal, then you expect that that might be taken up because of the serious implications. But on the one hand, you've got ASADA, and they've got decisions governed by the fact that they've got Australian taxpayers' money to consider and whether or not it's likely that an appeal might succeed. On the other hand, you've got the World Anti-Doping Authority looking closely at the matter, and they can either independently or no doubt have some influence over ASADA as to whether or not to appeal as a matter of, I guess, public process and transparency.
There's a narrative currently in play on Twitter and on Talkback Radio that Hurd and Essendon are effectively absolved. I'm seeing lots of talk about legal action. Would you imagine either party would actually seek legal action in any form, be it against the AFL, the media, whoever?
Well, if I can just deal with the media aspect briefly, that's in the nature of a defamation claim, and for a defamation claim to succeed you have to show that someone said something that's in a nutshell offensive and untruthful. And one of the key aspects of this case is a lot of the things that have been reported in the media, most parties would rely on the fact that they are truthful, and we've seen that on a number of occasions, and the only person that's sought to bring a defamation case, as I understand it to date, is Stephen Dank, and even in those cases they were discontinued at an early stage because of their lack of prospects of success. So my general sense is that it'll be pretty difficult for anyone to bring such a case. In terms of suing for any injury, we know that there's a few NRL players represented by a legal firm in a small class action at the moment, and their claim is for physical trespass of the body. That is, that they were injected with various substances of which they didn't know the particular type, and therefore they were put at health risk, etc., and effectively didn't give permission for what happened to happen. Similarly, some Essendon players could bring similar cases, but theirs is slightly different because we have signed agreements as to what they thought that they were taking, and unless you can prove what they thought they took versus what they actually took, and all of this case has been about that no one can prove what they actually took, there's a real difficulty in bringing that sort of case. But at the same time, we know that currently there is a case before the Victorian Supreme Court for one of the former Essendon players, and he's seeking medical records from both Essendon and the AFL so that he can establish whether or not he's got health concerns moving forward and whether or not he can bring a claim as to the risks to his health. And at the moment, there may well be others that join in his claim.
Paul Horvath, thanks for your time. We appreciate it.